U.S. immigration 2025 versus 2026. What actually changed this year? U.S. immigration changed a lot between 2025 and 2026. And if you're planning to apply for anything, these changes can directly affect your case. Hi, I'm Rachel Rado, and today I'm going to explain what actually changed, why it changed, and what it means for immigrants right now. Immigration law is always evolving, but the past year brought major shifts in enforcement, monitoring, processing, and eligibility expectations. Some changes make processes stricter, others make them more expensive, and overall, the system is becoming more controlled and more closely monitored. Let's break this down step by step. First, enforcement expanded significantly. One of the biggest structural changes is increased investment in immigration enforcement. Federal funding for border security, detention facilities, and enforcement personnel increased, which means more officers, more investigations, and more capacity to detain individuals during immigration proceedings. In practical terms, this means immigration violations are more likely to be identified and acted upon. It also means that enforcement agencies have more resources to monitor compliance, investigate cases, and process removals. This affects not only people crossing borders, but also people already in the U.S. who may be out of status or under review. Second, expanded expedited removal and stricter enforcement procedures. Expedited removal allows certain individuals to be removed from the U.S. without a full immigration court hearing. Recent policy expansion means this process can be applied more broadly in some situations. What does that mean for immigrants? Less time to respond, faster processing of removal decisions, greater importance of having legal guidance immediately if contacted by enforcement. This makes early legal strategy more critical than ever. Third, expanded biometric tracking and identity monitoring. Biometric data collection has expanded significantly. The U.S. government now relies more heavily on facial recognition, fingerprint systems, and entry-exit tracking to monitor immigration compliance. This applies at airports, ports of entry, visa processing centers, and sometimes within application processes handled by the United States Citizenship and Immigration Services. The goal is to track visa compliance, detect overstays, verify identity, and reduce fraud. For immigrants, this means immigration history is more precisely recorded than ever before. Overstays, travel patterns, and identity records are easier to track and verify. Fourth, immigration costs increase. Application costs have gone up under the updated structures. Many filings now require higher payments, and incorrect fee submission can lead to rejection of the entire application. This affects petitions, work authorizations, adjustment of status, and many other processes handled through USCIS. Why does this matter? Because rejected applications due to incorrect payment can delay our case significantly. And in time-sensitive situations, that delay can affect legal status. Planning financially for immigration has become even more important. Fifth, major changes to the H-1B visa selection system. One of the most talked about changes involves the H-1B work visa system. Historically, selections were made through a random lottery, but policy direction is shifting towards prioritizing higher wages and specialized roles. The goal is to select applicants based on more economic contribution and skill level rather than pure chance. This means employer strategy, salary structure, and job classification may now play a larger role in selection outcomes. For professionals and employers, planning the petition structure carefully is more important than before. Sixth, stricter compliance monitoring for visa holders. Monitoring of visa compliance has intensified. Authorities are paying closer attention to overstays, unauthorized work, status violations, travel patterns, incomplete documentation. Enforcement agencies like U.S. Immigration and Customs Enforcement have expanded monitoring capacity, which increases the likelihood that violations will be detected. This means maintaining valid status is not just important, it is actively monitored. 7. Mandatory detention policies expanded for certain cases. Some newer enforcement laws require detention for certain non-citizens accused of specific criminal offenses while their immigration proceedings are pending. This is a major procedural change. In the past, some individuals could remain free while their cases were processed. Now, detention may be required depending on the situation. This increases the legal and personal impact of immigration enforcement actions. 8. Tighter screening and travel-related restrictions. Screening processes for visas and entry have become more rigorous. Background checks, security reviews, and eligibility verification have intensified for certain categories and nationalities. Travel restrictions and entry scrutiny may change based on policy priorities, security concerns, and diplomatic conditions. For travelers and visa applicants, documentation accuracy and eligibility verification are more important than ever. So what does all of this mean overall? Immigration in 2026 is more monitored, more structured, and more enforcement focused, and more documentation driven than in 2025. Authorities have more data, more resources, more tracking capability, and more procedural tools. Small mistakes are easier to detect. Delays are easier to trigger, and legal strategy is more important at every stage of the process. If you're planning any immigration step this year, applying for a visa, renewing your status, adjusting your status, or sponsoring someone, make sure your strategy reflects current rules, not outdated information. If you want help understanding how these changes affect your specific case, schedule a consultation. Your immigration plan should match today's reality, not yesterday's system.